Tsiam Sahuayan, Tsiam Palmo. Want to thank Questum for his kind words of welcoming us here, and my friend Renee for her kind words. I was thinking on the way over from the ferry, I knew they were going to do this, and boy, it's kind of almost like being at a eulogy, isn't it? Let's hope we don't put you all to sleep. Want to thank you for being here this evening, and also recognize our relatives and my relatives here in the Coast Salish territory. My traditional name is Thalfit. Came from my grandfather. My uncle held a traditional ceremony to pass that name through to me. And I'm from Cowichan on Vancouver Island. So this evening I wanted to start by thanking all of the co-sponsors of this event, our great friends at Lawyers' Rights Watch, who have been tremendous supporters and allies in the work that we're doing, to Amnesty International, who have been such great supporters as well, and to the Vancouver Public Library for giving us this opportunity to share these messages with a broader range of the Canadian public, and share, I think, some important issues that hopefully you'll be able to use and understand. And you know, at the end of this, we hope that we'll have created enough understanding that the level and the base of support will continue to grow. I've had the opportunity to speak at a number of law schools across the country, and a number of human rights organizations, and I think the support for what we're trying to accomplish continues to grow. And so I think it's important that folks like yourselves are here to hear the message, and hopefully to be able to assist in spreading the message. So this evening I'm going to spend some time talking about the work that the Hul'qumi'num Treaty Group is currently engaged in. And we're currently doing work before the Inter-American Commission on Human Rights. And I'll talk a little bit more about them as we move on in the presentation. Here you'll see a collage of photographs. In the center is a group photo of the chiefs and delegation that have traveled to Washington, D.C. So the Inter-American Commission is located in Washington, D.C. They're part of what is referred to as the Organization of American States, of which Canada is a member. So we've been to Washington, D.C. now on 3 occasions to appear before the Inter-American Commission on Human Rights. On the right, the fellow in the red vest in the center is our lead legal counsel, Robert Williams. Robert Williams is a Lumbee Indian from the United States. He currently teaches at the University of Arizona. And the other photographs are members of the Inter-American Commission. And so, as I say, we've had the opportunity to travel to Washington, D.C. on 3 occasions. The Hul'qumi'num Treaty Group has 6 member nations. So the Cowichan tribes, the Halalt First Nation, the Lake Cowichan First Nation, Penelakut Tribe, Laxon First Nation, Seminas First Nation. There are over 6,000 members of the 6 tribes. We live on Vancouver Island, on the east coast of Vancouver Island. So from just south of Nanaimo, in the Ladysmith area, down to Duncan. So, and then over onto the Gulf Islands is the area that we currently live in. This is a photograph of our latest group of leaders that that travel to Washington to appear before the Inter-American Commission, some of our chiefs and elders, our legal counsel, and one of the members of the political executive of the summit, and also the chief of the community just north of us, the Nanaimo or Nanaimo First Nation. The issue that takes us outside of Canada and why we're seeking justice elsewhere has a long history. When the province of British Columbia entered Confederation, there was a negotiation that took place. And the outcome of that negotiation was one of the conditions that British Columbia had put forward to enter into Confederation was that the province would be connected to the rest of Canada by rail. So at that time there was a debate going on in the late 1800s about whether British Columbia would become part of Canada or whether British Columbia would become part of the United States. And it was decided that they would become part of Canada, and that this precondition, or one of the preconditions, was that they would be connected by the rail. They brought the rail here to Vancouver, but the political process in Victoria wanted it brought to Victoria. And so there was a fair amount of negotiation, disagreement, arguments, whatever going on between the federal government and the provincial government. And I think British Columbia at one point was threatening to withdraw from Confederation that quickly. It was eventually decided that initially they wanted the rail actually brought across the strait and then down. But that was cost prohibitive. So what they decided, and the way that they resolved it, was that they would build a railway from Nanaimo to Victoria, and then they would connect Nanaimo to Vancouver by ferry. The way that they financed it was that British Columbia granted to Canada 2 million acres of land. And the 2 million acres of land was the bargaining chip that they would use to construct that railway. So the 2 million acres of land you can see is that pink area on the east coast of Vancouver Island. When you look at this map, the area in green, and then that one area that's in kind of yellowy is the Nisga'a. But the area in green represents the Crown land in British Columbia. So you can see that in British Columbia, probably 80–90% of the province is Crown land. The areas in kind of that reddy pink color is what is referred to as private land. So you can see that one of the largest blocks of private land in the province is in fact that east coast of Vancouver Island, which was the subject of a 2 million acre grant to a private railway company. So at the time, an individual named Dunsmuir was a coal baron in Nanaimo, and he was quite closely associated with folks in Victoria, and he was able to secure the contract to build a railway from Nanaimo to Victoria. The payment was that the ENN Railway, as it became the Esquimalt and Nanaimo Railway, was given private fee simple ownership to the 2 million acres. So they got ownership of that land, lock, stock, and barrel. All the minerals, all the trees, all the land. That was done without any consultation, without any compensation, without any discussion with the First Nations. And since then, that 2 million acres of land has simply gone from one corporation to the next. And it goes through to today, where we have Island Timberlands, which is owned by a company called Brookfield. Hancock Timber Resources, which is owned by Manulife, and Timber West are the three large landowners in our territory. How this becomes relevant to the work that we're doing, so, you know, if you go forward from that date to 1997, when the treaty process was put into place, the Hul'qumi'num, the 6 Hul'qumi'num First Nations joined the treaty process with the expectation that, you know, we would be negotiating our traditional territory. And what we found out was that the Government of Canada and the Government of British Columbia had taken the view that private lands would not be on the table for negotiation. So it placed us in a very difficult position. 90-some% of our traditional territory had been granted away without our knowledge, without our consent, without our input, and without any compensation. And now the two levels of government were saying, and are saying, that those lands are not available to the Hul'qumi'num people for return. So we made a decision. There's we say that there's two streams of rights or laws that govern this area. The first is the domestic Canadian law. And we know that here in Canada that there is recognition for Aboriginal and treaty rights. That recognition is contained within the Constitution of Canada, Section 35 of the 1982 Constitution, as well as the Royal Proclamation of 1763, which is also part of the body of constitutional law. And as well, we have the common law decisions of the courts. So there is a body of law in Canada that says that First Nations have these existing Aboriginal rights and that they are in fact recognized and affirmed. The experience that we've had is there's a problem with the implementation of denial. Starting before the grant, you know, before 1870s, right from the beginning, just after Governor Douglas stepped down, that the province of British Columbia took a pretty sharp turn in their policy. During the time of Governor Douglas, 1840s, 1850s, Victoria had been actually negotiating a few treaties. So some of you may be familiar with what they refer to as the Douglas treaties in and around Victoria. After he retired, the policy became one of denial. That there was an absolute denial that Aboriginal people had land rights. There was an absolute denial that those land rights continued to exist. The government of British Columbia argued in the courts that their framework of laws had overtaken, had subsumed all of the Aboriginal rights, that Aboriginal title did not exist any longer in this province. And that attitude carried on right into, you know, when the Niska finally went to court in a decision called the Calder decision, and the Supreme Court of Canada split. 3 of the judges said the government was right. 3 of the judges said the government was wrong. And the 7th judge ruled on a technicality. And the Niska people lost that case. But it caused the government to reassess their position, because what the courts had said is that 3 of the judges of the Supreme Court of Canada disagreed with the government that in fact Aboriginal title continued to exist, that it had not been extinguished. You then go forward to the Delgamuukw decision in the 1980s, where the Supreme Court of Canada unanimously ruled that in fact Aboriginal title does exist in British Columbia, that it has not been extinguished. But even in the face of all of that, there has not been any government movement towards the recognition of Aboriginal title. The latest case to go forward is out of the Hul'qumi'num territory. Went forward to the British Columbia Supreme Court. Mr. Justice Vickers ruled that, in fact, the Hul'qumi'num, after many years and many millions of dollars spent, had proven that they had title, had led enough evidence that they had title to a portion of their territory, but because they had said in their court pleadings that they were going to prove title to 100% of their territory, he was not able to issue them a declaration that they in fact had title. So, in spite of the fact that the domestic law under the Constitution, in spite of the fact that the Supreme Court of Canada under the common law has said that in fact title exists, First Nations people do have land rights, First Nations people do have a right to have their title recognized, the government of Canada, the government of British Columbia refused to do that. They refuse to recognize title on the ground. What they say is First Nations people have to go to court and they have to prove it. So what we say is under domestic law, under domestic Canadian law, there is a serious implementation gap. There is a serious problem here. This could be part of the reflection of the problem. That Canada has no history of colonialism. So, you know, the attitudes under domestic processes, under the domestic political process, under the domestic legal process, there's some serious difficulties. So what we decided is that we would go outside of this country, that we would seek justice elsewhere, that we would go to a human rights approach. And under human rights, Indigenous human rights, under international law, there is this international system. Under the United Nations, there's general human rights, and they're contained in many treaties, international treaties, and international conventions. And then the latest document is the Declaration on the Rights of Indigenous Peoples. You know that document went forward. After many years of working on that document, it went forward to the General Assembly of the United Nations. There was a vote, and there were 4 countries that voted against it. The United States, Australia, New Zealand, and Canada. And Canada was, in fact, one of the greatest opponents of that, as we understand, and as has been reported, that Canada actively campaigned to get other countries on side. There's also another system. The world is divided into regions, and we live in the Americas. So there is another organization, another human right or another international organization, the Organization of American States. And Canada is a member of the Organization of American States. And the Organization of American States has a charter. And under the charter, the countries that are part of that treaty have committed themselves to respecting human rights. And the other part of this is that there was a declaration, the American Declaration on the Rights and Duties of Man, which is another instrument that talks about human rights. So Canada has signed on to that. Canada is a member, and they are, we say, have some certain obligations under that. Under this system of international law, then, there's two parts. One that they would call binding, or that it's hard law. And these are treaties and covenants and conventions, and countries that sign on to them must take steps to implement. And then there's customary international law. There's also an area that they call soft law, which are not binding in and of themselves, such as General Assembly resolutions, so the Declaration on the Rights of Indigenous Peoples. Canada takes the position that that document is simply an aspirational document. It's not binding on Canada. Even though they have now endorsed it, you know, even though they have now said that they are able, that they're prepared to support it. In our case in Washington, when we raised it, they raised the argument that it's not binding on them, that it's just an aspirational document. Declarations, of course, and then reports from committees. So I'll get into that in a little bit here.